Disqualifications of members. Article 190, Vacation of seats. Clause 1, no person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. Clause 2, no person shall be a member of the legislatures of two or more states specified in the first schedule, and if a person is chosen a member of the legislatures of two or more such states, then at the expiration of such period as may be specified in rules, but by the precedent, that person's seat in the legislatures of all such states shall become vacant unless he has previously resigned his seat in the legislatures of all but one of the states. Clause 3, if a member of a house of the legislature of a state, subclause A, becomes subject to any of the disqualification mentioned in clause 1 or clause 2 or of article 191, or subclause B, resigns his seat by writing under his hand address to the speaker or the chairman as the case may be, and his resignation is accepted by the speaker or the chairman as the case may be, his seat shall thereupon become vacant, provided that in the case of any resignation referred to in subclause B, if from information received or otherwise, and after making such inquiry as he thinks fit, the speaker or the chairman, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. Clause 4, if for a period of 60 days a member of a house of the legislature of a state is without permission of a house absent from all meetings thereof, the house may declare his seat vacant, provided that in the computing the said period of 60 days no account shall be taken of any period during which the house is prorogued or is adjourned for more than 4 consecutive days. Article 191, Disqualifications for membership. Clause 1, a person shall be disqualified for being chosen as and for being a member of the legislative assembly or legislative council of a state. Subclause A, if he holds any office of profit under the government of India or the government of any state specified in the first schedule other than an office declared by the legislature of the state by law, not to disqualify its holder. Subclause B, if he is of unsound mind and stands so declared by a competent court. Subclause C, if he is an undischarged insolvent. Subclause D, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or in under any acknowledgement of allegiance or adherence to a foreign state. Subclause E, if he is so disqualified by or under any law made by Parliament. Explanation: for the purposes of this clause, a person shall not be deemed to hold an office of profit under the government of India or the government of any state specified in the first schedule by reason only that he is a minister either for the union or for such state. Clause 2, a person shall be disqualified for being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Article 192, decision on questions as to disqualification of members. Clause 1, if any question arises as to whether a member of a house of the legislature of a state has become subject to any of the disqualification mentioned in clause 1 of article 191, the question shall be referred for the decision of the governor and his decision shall be final. Clause 2, before giving any decision on any such question, the governor shall obtain the opinion of the election commission and shall act according to such opinion. Article 193, penalty for sitting and voting before making oath or affirmation under article 188 or when not qualified or when disqualified. If a person sits or votes as a member of the legislative assembly or the legislative council of a state before he has compiled with the requirements of article 188, or when he knows that he is not qualified, or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by parliament or the legislature of the state, he shall be liable to respect of each day on which he so sits or votes, to a penalty of 500 rupees, to be recovered as a debt due to the state. Powers, privileges, and immunities of state legislature uh, and their members. Article 194, powers, privileges, etc. of the houses of legislatures and of the members and committees thereof. Clause 1, subject to the provisions of this constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. Clause 2, no member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes, or proceedings. Clause 3. In other respects, the powers, privileges, and immunities of a house of the legislature of a state and of the members and the committees of a house of such legislature shall be such as may from time to time be defined by the legislature by law, and until so defined shall be those of that house and of its member and committees immediately before the coming into force of section 26 of the Constitution, 44th Amendment Act 1978. Clause 4. The provisions of clauses 1, 2, and 3 shall apply in relation to person who, by virtue of this constitution, have the right to speak in and otherwise to take part in the proceedings of a house of the legislature of a state or any committee thereof, as they apply in relation to members of that legislature. Article 195, salaries and allowances of members. Members of the Legislative Assembly and the Legislative Council of a state shall be entitled to receive such salaries and allowances as may from time to time be determined by the legislature of the state by law, and until provision in that respect is so made, salaries and allowances at such rates and upon such conditions as were immediately before the commencement of this constitution applicable in the case of members of the Legislative Assembly of the corresponding province. Legislative procedure. Article 196, provisions as to introduction and passing of bills. Clause 1, subject to the provisions of Articles 198 and 207 with respect to money bills and other financial bills, a bill may originate in either house of the legislature of a state which has a legislative council. Clause 2, subject to the provisions of Articles 197 and 198. A bill shall not be deemed to have passed by the houses of the legislature of a state having a legislative council unless it has been agreed to by both houses, either without amendment or with such amendments only as are agreed to by both houses. Clause 3. A bill pending in the legislature of a state shall not lapse by reason of the prorogation of the House of Houses thereof. Clause 4. A bill pending in the legislative council of a state which has not been passed by the legislative assembly shall not lapse on a dissolution of the assembly. Clause 5. A bill which is pending in the Legislative Assembly of a state or which having been passed by the Legislative Assembly is pending in the Legislative Council shall lapse on a dissolution of the Assembly. Article 197. Restriction on powers of Legislative Council as to bills other than money bills. Clause 1. If after a bill has been passed by the Legislative Assembly of a state having a legislative council and transmitted to the legislative council. Subclause A, the bill is rejected by the council, or subclause B, more than 3 months elapse from the date on which the bill is laid before the council without the bill being passed by it, or subclause C, the bill is passed by the council with amendments to which the legislative assembly does not agree. The Legislative Assembly may, subject to the rules regulating its procedure, pass the bill again in the same or in any subsequent session, with or without such amendment, if any as have been made, suggested, or agreed to by the Legislative Council, and then transmit the bill as so passed to the Legislative Council. Clause 2.